Yes, but I have to...
something preliminary?
Yes, I do.
Okay.
I want to put something on the record. Yesterday, during one of the many bench conferences that we had discussing whether or not evidence was going to be admitted relative to a text message on a time frame, and I'm sure the court remembers that.
Yes.
Especially in lieu of the Duke Lacrosse case, the Virginia...
I'm sorry.
The Duke Lacrosse case, the Virginia case where false allegations of criminal sexual conduct were made and deemed and found to be false. At the time of our bench conference, when we were talking about the admission of this evidence, which I believe the defense believes, and I'd ask that counsel sit down while I'm making this motion.
Be seated. I will give you your opportunity.
Thank you, Your Honor.
We were talking about the admissibility, about where it come in. My position being that if this evidence comes in, it sets a timeline where this could not have happened. It's an airtight alibi.
Okay.
Counsel from Wayne County indicated that she turned that evidence over, but it's not her job to put it in. Well, I disagree.
We talked about this
I
this conference yesterday as to whether it was exculpatory under Brady and Crawford.
Correct, and this is why I want to make the record. I disagree. My job is to defend. My job is to advocate on behalf of my client. The reason the prosecutor comes through with the title People of the State of Michigan is because they have a different job. They have a different oath, a different obligation. Their job is to see that justice is done. The people of the state of Michigan, as represented by Kim Worthy's office, indicated that's not their job. What she said basically, and I'm paraphrasing that portion,
okay.
What she said is, I gave it to them. It's their job to put it in. No, it's their job to do justice. My response at the bench was that she should be racing to put in exculpatory evidence because her job is to see that fairness, justice, and truth prevail. So the idea that you turned over something that may indeed completely clear Mr. Cleaves, but somehow that's my job, her job ends at the water's edge, is completely wrong ethically. And I want that on the record. I'm asking that the case be dismissed today because they know, they now have sworn testimony, a timeline from Emily Brundell, a timeline, and they have text messages and phone calls from Mr. Cleaves that were turned over to me. They verified them. They know this case is not true. This case is going down the path of the Virginia case and the Duke Lacrosse case. They have an obligation, and I'm asking the court to ask them to do what they're supposed to do and dismiss this case immediately. Thank you.
Thank you, Mr. Midley. Ms. Lindsay, you'd like to respond?
Your Honor, as it relates to what I indicated at the bench, first of all, this case has to be held on its own merits. For counsel to start talking about other cases is simply a tactic to inflame the passions of the public as it relates to this case. Notwithstanding Mr. Manley's claim that the text message presents him an airtight alibi, it does not. The text message supposedly that was sent by the defendant was sent after the victim was brought into the room. After the first time, there is a 13-minute gap between the first time she was out of the room, approximately 13-minute gap between the first time she was in the room, when she was brought back into the room, to the second time she ran out. During that 13-minute gap, the sexual assault happened. It is totally consistent with our theory. And what happened in this case is that he brought her back in the room, he began to sexually assault her, he saw that it was not going the way he wanted it, that she was upset, that she was not complying, and then at that point he began to try to get his alibi together to cover what he had done by sending out his text. So what happened in that room is entirely consistent with what we're alleging happened in this case. And furthermore, notwithstanding the airtight alibi, if counsel is claiming that Mr. Mateen Cleaves was trying to get the victim help, how come he is not allowing her to use the phone? His theory, and that goes to the unlawful imprisonment, because he is still in control of when she gets out of the room. If he claims that he was simply trying to allow her or help her leave, why not give her the phone, let her make the phone call to get out of the room? He's still entirely claiming that, and then he talks about these other texts to other people, Brooke Adams or whatever. How come or phone calls, how come simply when she first ran out the room, why that large gap before he even attempts a call? So the defendant is still in control of how she exits the room. If he claims he was trying to get her help, how come he didn't call 911 himself to get her help? If he claimed he was trying to help her leave the motel, how come he did not simply call her a cab? If he wanted to help her leave the motel, how come he simply, when she first said she wanted to go home, did not take her home? So notwithstanding counsel's argument.
Excuse me just a minute. I want you to go back in your argument. Mr. Manley indicates, and remember, I've seen this exhibit. Mr. Manley indicates, and I'm not worried about an alibi.
I get a call, come back on it.
Just, yeah. I don't want to talk about alibi, all right? But I'm looking in my notes at the timeline right now. I want you to address, as you continue with your argument, Ms. Lindsay, that with what I saw yesterday, and it's not evidence yet, I just saw it and noted it. Depending on what it is, if it's correct, there was a telephone call or a text message sent prior to the first night. Just a minute, I'm saying according to what I saw. Prior to the first 911 call, you asked, why didn't he do this, why didn't he do that, why didn't he do the next thing? I want you, in what time I give you to remain, to argue. Remember, the court has many of the same questions about the alleged victim. Why didn't she stay in the gas station? Why didn't she tell the attendant? This is a two-sided thing. So I want you, please, to forget all that and go for me to the admissibility of that evidence.
Okay. The first 911 call happened at 2:01. This supposed
2:02.
Well,
that's what my notes
was
say.
the first 911 call that we had admitted to in this case happened at 2:02. But since counsel is referring to evidence that has not been admitted so far, I can refer to there was another 911 call at 2:01. Now, the text came at 1:56.
Which was before the first 911 call?
Before the first 911 call, but if you listen to the first 911 call, the lady said the woman has run out twice in the last half hour, so which meant she had already run out. You have to go back and listen to that 911 tape. The lady said she's ran out twice in the last half hour, so she had already run out once. Okay, and the court has not viewed the video, the entire video, but we put the entire video in so the court could see that. But even if the court looks at the time differential between the first time she ran out and the second time she ran out, you have it in the still photos. There is at least a 13, I think approximately 13-minute gap between her running out the first time and the second time. So even though the first 911 call came after he supposedly made his text, she had already run out at that point, and she said the assault happened when she was taken back into the room between the first and the second time. So it is entirely consistent that once they got back in the room, the victim indicated that he began a sexual assault on her.
And at this point, it's entirely consistent that something happened. I don't know what, but something happened at 1:56, which would have been prior. Now, address for me your responsibility as a prosecutor to, number one, disclose exculpatory information, and number two, to be fair.
Okay.
And let me address it specifically this way. If you have evidence, which I saw there might be, that there's exculpatory behavior, why are you not presenting that evidence to allow me to make a decision as to whether there's probable cause or not? And please don't use trial strategy, because this is...
I'm not saying trial strategy. The court, I think, and I
Don't
think...
you think you have a duty? That's my question.
The duty is, and my duty is, I did in fact turn it over. My argument is I do not believe that that is exculpatory, but it was turned over. And if the court reads the cases on Brady and everything, the court requires that it be turned over. That's what it requires we did, and we did turn it over. The probable cause hearing is where I present my case, and my position is, despite counsel saying it's exculpatory, I don't think it's exculpatory at all. I turned it over. It's not exculpatory because it does not absolve him.
Okay, and that's your theory. I
Right.
understand it, Ms. Lindsay. What if the court feels differently? What if the court, on viewing this information, thought, well, I'm not saying maybe the court would think this is a complete alibi, but what if the court says, and this puts a little bit different spin on things? Don't you think I should have that opportunity to look at that evidence?
Due process requires that I turn it over to the defense. That is what the law requires. That is what the Constitution requires. I have done what the law requires. And I don't have to put in my entire case at the preliminary examination.
You don't.
And so I have done what the Constitution mandates that I do. Now, just because counsel wants to claim that that's exculpatory, there's a lot of other stuff that the court has not heard at this point that we're not going to put in. The court has not heard at this point that when the police came up, when the police approached...
Don't tell me if you're not going to introduce it. Don't tell me.
Well, if Johnson and Ogle testify, and they are here to testify, it will come out.
Okay.
Because I did subpoena them, that when the police approached the scene, the defendant took evasive maneuvers before he was pulled over. He did not immediately stop. That is, as it relates to the criminal jury instruction, evidence of attempted flight, which goes to consciousness of guilt. There's a whole lot of things that the court is not going to hear or may not hear at this juncture. But Brady, and I have all the cases, I pulled them on Brady, requires that I turn it over. And I turned it over pre-exam.
Okay.
That's all Brady requires.
Okay. Mr. Manley, you want to respond?
I do. You know, just because somebody talks fast or bobs their head,
I'm sorry, Mr. Manley. What?
The manner in which somebody says something doesn't mean you can't put earrings on a pig and have it not be a pig. The fact of the matter is, this case is a pig. And the fact is that they have gone forth with a theory, and just because you say, I've got a case, it's like a little kid. He who protests too much. They know. And she argued facts, and she, the representative of the county of Wayne, and so forth. But the fact of the matter is, she knows the timetable. If her complainant is to be believed, she came back in to the room, was laid on the bed, she doesn't know how she got out of the bed, pushed off, and came out almost immediately. Which means at 1:56, at 2:01, the calls come in. They're out there. So Mr. Cleaves is calling, and if we're going to get into the facts of the matter, he's calling her boyfriend. Which, if we're going to go one step further, the person that she keeps saying, I want called, is my boyfriend. So Mr. Cleaves is calling the boyfriend, texting the boyfriend, which is entirely consistent with what the complainant said. Not only that, Mr. Cleaves is placing, and they know this. They know this. You can talk about Brady. Brady's turning it over. It's like the Pontius Pilate. I wash my hands of it. No, your duty as a prosecutor is to do the right thing. That's why the La Crosse prosecutor was disbarred, because they knew they weren't doing the right thing. They know that these calls were being made. They know. Naring, sitting right over here, took the information. There's 4 calls that are made supposedly during the time that Mr. Cleaves allegedly is sexually assaulting this woman. 4 calls. That defies credulity. And to stand here, then you say, run out. Wait till you see the film.
I've seen it.
It's a walkout. The lady testified yesterday that she was out to getting some air the first time. Colleen Dowdell testified the reason she didn't call 911 is because she didn't see anything to call 911 about. They said it was a noise violation. And when they get to, because counsel brought it up, when they get to, and if they do their job correctly by their oath, they'll put the officer up who said that he interviewed the complainant and that she said she was not assaulted. Not at all. So if they do their job, they will put the 20-year police veteran on the stand who will say the first person that this lady talked to of authority that wasn't her boyfriend or her mom said there was no assault. They have a duty. You can't get rid of the duty by saying I turned it over. You can't shift the burden. The duty is to do the right thing.
You really think you can't shift the burden?
They're trying.
Okay, first of all, I'm going to tell you right now, I'm not going to dismiss, and here's the reason why. Just within this last year, I dismissed the case before I completed the preliminary exam because I felt it deserved to be dismissed. I was corrected by the appellate court, and I was told I must listen to the complete examination. So, before I dismiss, I must listen to the complete examination, and I will continue, or I will consider your motion as continuing.
Thank you, Judge.
As to the exculpatory information, I believe, and I can't base this on any statute, case law, or anything except my sense of fairness, that the complete case should be put on in terms of probable cause. Not the complete trial. I am not the trial judge. I am not the jury. This is simply a probable cause hearing. I believe that Ms. Lindsay mischaracterized the testimony, or I misheard it, one or the other. But Ms. Dowdell said that Mr. Cleaves, by the time the police got to the room, Mr. Cleaves was up at the front and he was walking. I believe that's what she said. Now, maybe she didn't. But that's what I think. So any talk about a flee and elude, a attempt to escape, that's not in evidence. It's just not at this point. I'm waiting to hear from the first responders. I hope I do.
Excuse me, can I direct the court, because remember, I'm sorry, the court indicated you thought she said she was walking, but
That's what I thought.
But remember we played the squad car video where Colleen...
I don't remember that. No,
we played,
you may be right. I'm not saying...
We did. I don't know the exhibit right now. We were the squad car.
It's 100.
Yeah. We played 100.
Just a moment. Let me look at my list, please. I don't remember that coming in as an exhibit.
Judge, the whole thing that maybe I can
I
jump ahead of this and give it to the court. And Miss Lindsay knows this. If there was an attempt to evade the police, which she's talking about flight, which is absurd, the police wouldn't have driven Mr. Mateen Cleaves home.
Absolutely.
And this is
you can't say that, Judge. You can't say that. You haven't seen the video. You don't know that. You're making a...
Wait a minute. You can't both talk at once.
You said precisely like, you don't know that. If he tried to get around, because... Okay, we'll just have to show the video.
I'm going to have to see the video as to that point. I am not denying your motion, Mr. Manley. I'm just telling you that it's too soon,
Thank you, Judge.
all right?
I understand.
Now, as long as we haven't got the witness in the room, let me say this. Miss Lindsay, you have continuing objections. You have continuing objections as to relevancy, speculation, and argumentative questions. I would like one of your team, I don't care who, to make notes of each time you claim relevancy, speculation, or argumentative. And I will give you time to argue those, but not during the cross. The same goes with you, Mr. Manley. You have continuing objections. Have one of your team make notes, and it will each give you and Ms. Lindsay an opportunity to argue those on the record to keep your record perfect. But I'm going to, at this point, have a seat, Ms. Lindsay. I'm going to, at this point, consider any relevancy, speculation, or argumentative to be a continuing objection, and I will give each of you the opportunity to address that. The only time that these should be objected to is in the presentation of an exhibit where it's critical that I not see it. All right?
Yes, Your Honor.
All right.
Can I just say one additional thing? The second 911 call, which was admitted, which I think is exhibit number 6, Colleen Dowdell said he's getting in his car and leaving. That's what she says in the second 911 call.
She might.
So,
She might.
okay.
I just made the note that they were up at the front. That's all I knew.
And the other thing, Judge, is I understand the court's ruling, but effectively the court has given the people no remedy. Because if we object to something that's not relevant or whatever, and the court lets it be said or lets it be put on the record, even if the court strikes it later, the damage is done. Because as it relates to this hearing, it's being live streamed. And in terms of...
What does live streaming have to do with anything
Tainting,
in terms of how I decide probable cause?
because things that come out may taint a potential jury pool if it should have never come out and been said in the first place.
And you don't think things haven't already come out that would have tainted the jury pool and you yourself said them?
Judge, but I'm talking about the here and now. I'm not talking about in the past. I'm talking about the here and now, and I'm not talking about a situation where I have never been in a situation where I have not been allowed to make objections as the questions come out to remedy the situation right then.
I'm not saying you can't remedy the situation. I'm saying object, but it's continuing. And I will address each one. I told you yesterday, under 611, I'm allowed to control this. And yesterday, the beginning of the cross-examination was so choppy, I could not understand any of it. When I came back and asked you, please, and you too, to limit your objections so that I could get a feeling for the testimony, we had a good amount of time where I was able to get testimony. This is an important witness to me. So, you know, and I'll read 611 if I have to. To make the interrogation and presentation effective for the ascertainment of the truth. That's my first obligation. And if it's so choppy I can't understand it, then something's got to be remedied. And Ms. Lindsay, I'm going to ask you to give me a little credit, ma'am. I am not a jury. You can unscramble my mind, all right? I'm used to listening to evidence that comes in that shouldn't have and discounting it. And I sit right here with a red pen to cross it off. Okay, anything else?
Basically, you're saying to hold those objections so we can actually have some...
No, make the objection relevance, but do not argue it. It's continuing, and I will give you time.
And the leading question objection is continuing as well.
I'll add that one, too. Because there's been quite a bit of leading.
Thank you, Judge.
Anything else? Okay,
No, Your Honor.
let's bring back, are we going with Ms. Brendel? Ms. Lindsay, ma'am, are we going
Yes.
with Ms. Brendel? Okay, go off the record.
I just want her to say.
What'd you do?
Oh, I think it's suppression.
No.
Aren't you ever out of the game?
All right. Just be seated. While we're waiting and while we're off the record, don't forget that I have exhibits and case law that I do not want to keep, so make sure when we're done, I give it back to
Okay.
whoever it belongs to, okay?
Thank you.
Good morning, Ms. Brindell.
Good morning.
We need to go back on the record, just give us a minute. Okay, we're back on the record in the Mateen Cleaves case. Ms. Brindell, today, because it's a separate day, I'm going to re-swear you. Would you raise your right hand? Do you solemnly swear and affirm to tell the truth in these proceedings?
I do.
And you don't need to state your name and spell it, we have that. Would you take a seat at the witness stand? Ma'am, please keep your voice loud. Remember I said yesterday, talk to the deputy in the back of the room. Okay, are you ready?
Yes, I am.
Mr. Manley, you may proceed.
Good morning, Your Honor, or excuse me, thank you, Your Honor. Good morning, Ms. Brendel. Yesterday, I asked you a series of questions regarding this incident, is that correct?
Correct.
And you answered them to the best of your ability under oath. That's what you said, correct?
Correct.
And there were a lot of times when you said you didn't remember, is that correct?
Correct.
Okay. One of those times that you said you didn't remember is when you arrived at the motel, is that correct?
Correct.
And I asked you, I said, do you remember being there, right?
Yes.
And I asked you, do you remember being in Mr. Cleaves' car?
Yes.
Right. I asked you if you remember fixing your hair, right?
You asked, but I don't remember that.
Yeah. I asked you if you remember going into your purse, and there appeared to be some kind of compact and fixing your makeup, and you said you didn't remember that, correct?
Correct, and that I don't remember.
And I remember I asked you if Mr. Cleaves had gotten out of the car, and you were in the car, and the car was running, and you were in it, and you said you didn't remember that, right?
That's correct.
Mr. Mr. Muscat, at this point in time, Your Honor, I'd ask that the court play proposed defense exhibit A.
Okay, for the record, please describe what proposed defense exhibit A is.
Proposed exhibit A is Mr. Cleaves pulling up to the motel, getting out of the vehicle, leaving Ms. Brendel in the vehicle running, him going in there, her fixing her hair and adjusting her makeup.
This is part of what's listed as the full video, correct?
That's correct.
He's gonna have to have it separate, marked as a separate.
It is marked as a separate. I'm trying to ascertain where it's coming from. It's coming from the full video, correct?
No.
No,
No.
Judge, it's not. I can explain where it's
Would you
from.
please, Mr. Muscat?
Okay, there is a disc that was recovered by Detective Nearing, and it's not marked as an exhibit in this case. It's from a different camera angle.
It is marked now, sir. It's
No, I
proposed
understand
A.
that. I'm just trying to trace this back. The
Okay.
disc that Detective Nearing recovered that captured this video angle has not been marked previously in this case.
Okay, I understand.
What they did was took one video file from that disc and they marked it as Exhibit A. We don't have an objection to the foundation of that, but it's not a camera angle that you've seen before in this case, and it's not from a file that's been admitted, just so the record is clear.
Okay, and I think, Mr. Muscat, I knew that.
Okay.
What I was trying to get from the two of you is this comes from what Detective Nearing recovered from the hotel.
Right.
Right, but it's not what you keep referring to on the exhibit list is the full video.
Okay,
That you
now I
keep-
understand
Yeah.
what you're trying to tell me.
It is a video from the hotel, but from a different camera than
Right.
the,
But it was retrieved by the police, it was
Correct.
kept in custody by the police. It came from your file, Mr. Muscat?
No, it came from the file that Detective Nearing gave me. Again, we don't challenge the foundation. It's one of the
Right.
videos that were collected in this case.
Then are you stipulating that the defendant's proposed A can be admitted?
Yes,
Right.
to help the record, the video file has a name on it when you view the video. It
Mhm.
says camera front right parking.
Okay, just a minute. Camera, front right parking?
Yes, the only thing I have to do is switch the cords, Judge, so I can connect it to, I copied it from
Okay,
there.
good.
For the record, Mr. Manley's assistant gave me the disc. I copied it, and I marked it, I changed the file name to Exhibit A because I have a digital copy of all the exhibits that I'm going to present to court on a disc at the end of this exam.
Okay.
I just have to switch the cords to put it on your monitor based on previous rulings.
Is my monitor still there?
Yes, it is.
Okay,
Mr.
now
Champagne
stop.
can help me.
Stop.
Yes, ma'am.
Let's discuss these previous rulings business.
May we approach?
Yes.
All right.
Yes. I thought it was, yeah.
Unplug a cord, I just don't want to.
Is it so clear right here?
You don't have to move it.
Who's going to play that for you, Mr. Muscat?
Yeah, I have it on my computer, Judge, and I told the defense that I would play it for them so they don't have to hook up their own equipment.
You just need, do you need this monitor?
Yes, Judge, and I just have to grab an adapter from my bag.
Oh. Yeah, just so we can plug in whatever it has. Oh, okay.
Yeah, she'll have to step up like the other witnesses did, so the witness can see it. right?
Okay, that's fine.
Judges,
What I-
is they not playing it up here?
No.
Okay.
That's all. She just wanted to go check.
Can we go back on the record, please? Okay, we're on the record in the Cleaves case. Ms. Brendel, I've made some rulings with regard to what videos can be shown in the courtroom. And the video exhibit that they're going to show right now is one that I'm not allowing the public media to see. But you're going to be asked about it, So I'm going to ask you if you can come right up here, ma'am. And I'm indicating to the left of the bench. I'm going to turn the monitor. Can you see it, ma'am?
Yes, I can.
And you see it clearly?
Yes, I can.
Can you keep your voice up because your microphone's clear over there?
Yes, I can.
I wouldn't do that. Just totally on this stuff.
Judge, can you see an image on there right now?
Yes, I can.
Okay. And it
Now,
says camera
I
photo
gotta ask,
parking?
is this video one that the time is off on?
Well, at this point, we can't, it's approximate. Our best answer would have to say approximate for purposes of this record at this time.
Okay, Mr. Manley?
I would agree with that.
Okay.
At times I have a continuing
So all I'm
objection to
looking
the
at
time.
is the content of the
Content.
photo, not the time.
That's correct.
Okay.
All right, so on the video, Judge, it begins at a time that's indicated as 1:28:17 a.m.
And I see a handicap parking space.
Right, and I'm just going to start to play it right now.
Do you see that?
Yes, I do.
All right. Mr. Manley, get to a microphone.
He's watching the video.
Oh, okay. Stop the video. Have you seen it, or do I need him to back up a couple of seconds?
No, I've seen it.
All right, go ahead then.
Judge, can you see on ours, it says camera
The-
front right parking?
The
Can you
writing
see-
is completely over anything I think you'd want me to see.
Yeah, that's the problem. Is there any
I
way
think what they're
to-
trying to show is this area right here. Ms. Brendel, can you see what's going on in this area?
No, the writing's over it.
And what I'm pointing to is whatever is appearing underneath the letters NT in the word front.
That's correct. Let it roll a little bit, because maybe once the lights come on, you can see a little better.
All right.
And then if I have to try to have somebody who has certainly more technical skill than myself, see if we can take that writing off, I will do that.
Now I'm seeing what appears to be somebody's arm that's wearing light clothing. And I'm seeing a reflection of something or bugs in the camera light, one or the other. Okay, I saw a person exit.
For the record, Judge, I asked counsel if I could stop it at 1:29:48, strike that, 1:29:58, as listed on the video.
I do not want it stopped.
Oh,
I want
okay.
it to go just a tad further to see if the witness and I are capable of seeing who appears to be the front seat passenger in that vehicle.
Okay, Judge.
Okay, thank you.
Okay, and I stopped it, and of course I just clicked
So for
off.
the record, we're at 1:28:16.
No, it rewound. I stopped it about 2 seconds after the previous mark that
Okay.
I gave for the record.
All right.
For the record, the car pulled out of the screen.
Right,
That's
I
what
saw
was
that. And for the record, the car pulled out of the screen without, well, I'll wait till that comes out on cross, all right?
Judge, at some point in time, in compliance with the court's rulings, I'm going to ask that the court view that on a larger screen, because when you view it on a larger screen, you can actually see if the witness, maybe with privately with the witness. I don't know how we can adjust it, but because of the way the small screen and the camera language above it kind of cuts off what the pertinent part why I was having it played.
We can break, when we break for lunch, Or do you want me to do it now before you question?
Could you do it now?
Then what I have to do is clear the courtroom of everyone,
That's fine.
including the camera people.
It's important.
And the press. I have to clear the courtroom of everyone. The only people that can stay are the attorneys, the witness, myself, and the court recorder.
It's
And the defendant,
important.
of course.
Yeah.
Okay, so let's clear the courtroom. You know, you're gonna come right back in, so. Ms. Brendel, why don't you just come over? No, I want it on the record. Yeah. Ms. Brendel, they're gonna do this on the polycam right behind you. Why don't you step over to the microphone in front of the Miss Lindsay? So if you need to speak, that microphone will pick it up. Camera guys, you're out.
I know. Yep.
Oh, excuse me, Mr. Bigger.
How's it going?
Oh, okay.
Deputy, you and that deputy stand right in front of these glass windows.
Right here.
Okay.
Okay, let's go back on the record. And I've asked Ms. Brendel to stand in front of the prosecution table. The exhibit is being shown on the court's polycom. I'm not sure, Mr. Manley, that standing in this position, as I am near the podium, that I'm going to be able to see it with my eyesight. So I'm going to move up to the corner of my bench.
I would hope the court would sit wherever the court deemed appropriate.
Yeah, I just, I'm toggling the view.
Ms. Brendel, can you see from where you're at?
Right now I can.
I recommend that you move up.
Can we make that?
Would you move up with Ms. Lindsay,
Thank
please?
you, Ms. Muscat.
All right, it's paused. Should I play it, Judge?
Well, we're paused at 1:28:18, and Mr. Manley, I think we should go ahead. What do you think?
I do, Your Honor.
All right, let's go.